Hi everyone, it's 7:30 according to my computer clock, so we'll go ahead and get going. I'm happy to see all of you here, and since you're veterans, I won't go over the rules of engagement. We'll just go right into our topic, which is the question of Shylock and Jewish law. This might seem to be a very esoteric topic, and I guess in some ways it is. But I hope to show that how the combination of this abstract question and a great rabbinic learning created a paper, created an argument that has ramifications that are not in the very least abstract, but cut to the very core of halakhic issues that we deal with today. I assume that everyone knows the story of the Merchant of Venice, that Shylock is convinced to loan Antonio an amount of money, and the collateral is a pound of flesh. And the drama of the story is, of course, that Antonio can't pay him back, and Shylock takes him to court to extract this pound of flesh. The question that we're going to ask is if, now I can't figure out how to move these things. There we go. This is the beginning of the classic article. We're going to look at Mishpat Shylock Lefi HaHalecha. The law of Shylock according to Jewish law. But before we do that, I thought we would learn a little bit about the personalities involved. And the first person we're going to learn about is a man named Rabbi Shlomo Yosef Zevin. Rabbi Zevin was born in Minsk. He grew up in both the Lithuanian and, mostly in the Lithuanian, but there were Hasidic influences on his life, certainly. He made Aliyah in 1935, and he created both a form of Jewish writing that managed to become really the predominant form of Jewish writing in the 20th and into the 21st century. And he inaugurated one of the greatest literary projects of all of Jewish law and literature. As to the form that he developed, and it's really called the halakhic monograph. The halakhic monograph differed from what went before, in that it's not really trying to answer a particular halakhic problem. Traditionally, a tshuva would try to answer a specific question, or a code would try to give guidance ahead of time of what to do. What the monograph is really interested in is just presenting all of the opinions on the topic as a reference, so that if somebody is interested in, say, the Kabbalat Shabbat, we'll have a monograph for Kabbalat Shabbat. If somebody is interested in counting the Omer, there'll be a monograph about counting the Omer. It's somewhere between traditional Jewish religious writing and academic writing. And this was something that was new to Judaism, not totally new. The Goanim did something like this, but to be at the center of the Jewish literary enterprise was new. His first major work was Moedim L'Halecha, which is the writings of the holidays, all according to this monograph form. He also wrote many articles about the halachas that were important to settling the land of Israel. For instance, if you have a question about the Shemitah, the this, which is happening this year, actually, you would want to consult. You could consult an article by Rebbe Zevin on the Shemitah. If you wanted to read about the obligation to fight in the army, or the obligation of Israel to go to war, when can Israel go to war? When is it permitted to fight? He wrote articles that dealt with those issues. He also, for any given topic of interest, he could produce a comprehensive monograph on it that would become the defining work on the matter. When we studied the halachas of snow back during the winter, the basis for this was this monograph that he wrote about Shylock, snow. Or if you're interested in the what halachas do we learn from the binding of Isaac? What halachas do we learn from the Kuzari? What's the significance of the number 13 in Judaism? He would write about those things. Additionally, he was a founding editor of this project, the Encyclopedia Talmudit, the Talmudic Encyclopedia. And this is simply strives to be a comprehensive guide to all of the topics of the Talmud. For every topic, all of the interpretations and opinions of the Rishonim and the Achronim are presented. Now, it's a wonderful, wonderful work. The downside to any sort of wonderful work like this is that you trade off. You trade off being comprehensive for actually finishing the task. Presently, I think they're up to Lamed. But they finished the Chicago Assyrian Dictionary, so maybe they'll finish this too. But he was one of the original editors of this project, and it's his article, Mishpat Shylock Lefi HaHalacha, and the role that this played in Jewish thought going into the later part of the century is something that we're going to explore today. The first question, so the thing that Zevin wants to ask is basically, if Shylock brought Antonio to a Jewish court, to a Beit Din, would the Beit Din require him to give up his pound of flesh? How would a Beit Din respond to Shylock's lawsuit? For parts of this question, he could go to, sadly, problems in Jewish law that had existed before. The first question: can one use one's body as collateral for a loan, as Antonio did in his loan to Shylock, had to be answered in the 14th century by a man named Rabbi Asher ben Yechiel, the Rosh. The Rosh was born in Western Germany, but because of the persecutions, he fled to Toledo, where he, despite being Ashkenazi, he became a very important rabbi in the Sephardi world. His son wrote the Torah, which is one of the early and greatest codes of Judaism. But the Rosh, Rabbi Asher ben Yechiel, he was writing at a time when the communities all over, both Jewish and Christian, were struggling with the question of what do you do when people don't pay their debts. It's a particular problem as societies become monotonized, as more money shows up. As we see in our world today, this is something that we struggle with. And there were many people who wanted to take very extreme measures in order to have debts repaid, or to punish the people who could not pay them. I mean, for instance, we begin to see debtors' prisons arise, where people who didn't pay their debts would be incarcerated. And we have to confront the question: can somebody who doesn't pay their debts be beaten by a court? The Rosh resisted many of these harsh plans to have people pay back their loans. And he had to answer the question: can a Jew write a contract with another Jew that's a loan that uses his own body as collateral. That's to say, if I don't pay this money back, you'll become my slave. If I don't pay this money back, I'll become your slave, rather. And Roche answered in the negative. He said that the law of Eved Ivri does not apply in our day, that Jews can't be slaves to other Jews. And moreover, though the Torah describes circumstances where one may have to sell oneself explicitly, the Talmud reads these verses as being limited. That is to say, the Torah says that one can be sold in order to pay back something that is acquired by thievery. And the Talmud says that, well, it's only for thievery that you can do that. You can't. That's not a general license for people to be sold into slavery for debts or for other things. And so, looking back to the 14th century, Rebbe Zevin is able to cite this case where it says, well, the contract that they made to leave the body as collateral, as Antonia did to Shylock, could not have been enforced by a Jewish court. The piece of it where he said, "Take the pound of flesh," they could not have forced him to take the pound of flesh. The question then remains, well, does Antonio have to pay Shylock anything? Does the fact that there was this item in the arrangement that was forbidden, does that invalidate the entire debt? Or does Antonio still owe Shylock the money, but Shylock's not allowed to collect the collateral? And this question, too, is dealt with in the earlier sources, and we're going to look at a section of the Talmud on this, which is a little, it's a little convoluted, but I think you'll find it very interesting. It's a principle from Devarim that you shall not bring the fee of a whore or the pay of a dog into the house of the Lord your God, in fulfillment of any vow, for both are abhorrent to the Lord your God. I see that Barry has a question about the Rosh. Does that ruling also apply to non-Jewish debtors? Well, that's a very delicate question. That's a very delicate question because that cancels out the Rosh's statement that we don't have the doctrine of Eved Ivri anymore, because even if we don't have the item of Eved Ivri, then we'd have the item of Eved Kanaani, or the Eved non-Jew. It's a delicate question, and certainly certainly you can see that for the sake of for the peace between the communities, Jews being a particularly vulnerable minority, we'd want to come to a position, at all costs we would want to avoid legal decisions that had Jews collecting non-Jews as slaves for not paying us our money back. So that would be, so as a practical matter, we'd want to avoid that at all costs, I think. Very good question. Very good question. So we have this doctrine that you shall not bring the fee of a whore or the pay of a dog. A pay of a dog is just a fancy way of saying a male prostitute, into the house of your Lord your God in fulfillment of any vow, for both are abhorrent to the Lord your God. And now, this is the, fundraising is always a problem for religious organizations. And in olden times, particularly in the Near East, there was this institute of the temple prostitute, in which either money would be raised directly for the temple by coercing women, and I suppose men, to prostitute themselves, and the money would go to the temple, or people who owed money to the temple for a debt or for something else, and they didn't have the money, they would seek to raise the money by prostituting themselves. And the book of Deuteronomy says, don't do that. Don't do that. That's terrible. It's abhorrent to the Lord your God for you to raise money this way. And we're going to put a stop to this. This was We're not going to do what other people do. There are limits to what you can do to raise funds. And this comes up in the question of, can prostitutes sue their clients for payment? Because this is an example of an arrangement where part of the arrangement is forbidden. I mean, you're not allowed to prostitute yourself or someone else, but at the same time, there's potentially an element of it that could be enforceable by a court. And so so it comes up in the tractate Bava Kama, which is a tractate of Talmud that deals with torts. The hire of a harlot was prohibited by the Torah from being used for the temple, even when given by a son for having incestuous intercourse with his mother. And this is a great Gemara. Irrespective of the fact that were she to have claimed it from him before us in the court, we should not have been able to order him to go and give her the hire. So let me take this apart for you a bit. There's an assumption in Jewish tort jurisprudence that if one is simultaneously liable for death and a fine, the fine's canceled. It's on the house. We're not. The death is enough. Death is plenty. And so we have here the case of the mother suing her son for the agreed price of prostituting herself to him. He would be liable for the death judgment if it went against him. Therefore, the money cannot be claimed in the court. So the son agrees to pay the money to his mom for sexual services. The mom is going to use the money to pay her debt to the temple. A great story. And the problem here with this principle is that if she takes him to court to enforce the payment, he would automatically also be liable to the death penalty, because it's a death penalty offense to have sex with one's mother. So in this case, the money cannot be claimed in court. And the question then arises that the Gemara is working with, that even though the money can't be claimed in court, it is still forbidden to use that money by the mother when collected to pay her debts at the temple. We're saying there's no loophole here. Just because the money could not be collected in a court case does not mean that money could be used to pay her debts at the temple. That they're the wages of harlots, even though the court can't collect them. And the inference which is made here by Rebbe Zevin is that if the case did not involve a death penalty, and that's to say, if we were just looking at a case of prostitution between people unlike a mother and a son who didn't have any penalty of death for the sexual relationship, in that case the funds could be collected even though prostitution is forbidden. And that's to say, you have an agreement with non-forbidden parts and forbidden parts. You don't enforce the forbidden parts, but the non-forbidden parts of the agreement can be enforced. So in this case, even though Shylock cannot take the pound of flesh from Antonio still has to pay Shylock back the money. The fact that there was an element in the agreement that was forbidden from Torah law does not nullify the entire agreement. Antonio still has to pay. And if this was all that Rabbi Zevin was working with, it's very interesting. But the article would have never had the impact that it had, except that he went on. He said there's a very important hypothetical question that we need to ask. And that's, even though we've decided that the court cannot compel Antonio to give the pound of flesh, what if Antonio agreed to it in order to settle the debt? What if Antonio said, I'd rather give up a pound of flesh than 1,000 lira? I forget what the unit of money was, but I'd rather do that. Or what if Antonio insisted on doing that, saying that this is the way that I want to do it? If Antonio gives consent for that, could we permit Shylock to accept the pound of flesh in lieu of payment? And Rebbe Zevin's great argument of the paper, and the reason that this paper is considered to be a classic in halakhic writing, and the reason that it still echoes today in practical halakha, is that he makes the contention that Antonio could not have agreed to the removal of his flesh, because it's a principle of Jewish law that we do not own our own bodies, that our bodies are owned by God. And unlike, say, Lockean jurisprudence, which is based on self-ownership, in Jewish law, we don't assume that we have total control over our bodies, that our bodies are owned by God, and therefore we cannot give people permission to hurt us under Jewish law. And therefore, Antonio does not have the authority to give Shylock permission to take his pound of flesh in lieu of the debt. And I can't go over the entire argument with you because he defends this at length, but I want to give you a taste of the sources that Rabbi Zevin brings to this. We have a Gemara in Sanhedrin, which deals with the fact that there's a death penalty not just for killing your parents, but there's a death penalty for even striking your parents. And there's certain questions arise. Well, why do we need both of these? If you get killed for striking your parents, you certainly get killed for killing them as well. But along the argument of doing this, the Gemara asks, may a son let blood for his father? That's to say, the father has a condition that requires that he be bled. And that was what medicine was. I think that's what barbers did. I think that I heard somewhere that that's how George Washington died. They just bled him too much. Well, he had a good run. But the Gemara asked me, a son let blood for his father. Rebbe Matnas says, you shall love your neighbor as yourself. In other words, if you would want that done for you, you're entitled to do that for someone else, even though we have this halacha that you may not strike your parents, and that bleeding your parents, cutting them so they bleed, would be a form of striking them. Just as one who strikes an animal to heal it is not liable for damage, so if one wounds a man to heal him, he is not liable. Rav would not permit his son to extract a thorn from his flesh, since in drawing it out, he would make a slight wound. And he's worried about that. Well, we have this exemption. We have this exemption for medical treatment. But what if the son makes a cut that's a little larger than is required for medicine? What if part of it turns out to be not medicinal? Or what if it turns out not to be required? I mean, the fact is that it doesn't matter that Rob gave him permission to do it. If it's not for medicinal purposes, his son is liable for striking his father. And again, Mar, the son of Rabina, would not permit his son to lance a fester for him. Like a boil, I think, lest he wound him, therefore unintentionally transgressing a prohibition. So the Gemara seems to clearly limit the circumstances in which a son or daughter can treat their parents, because the injunction of the Torah, he who strikes his mother and father is put to death, cannot be waived. That's to say that you are only allowed to do surgery or to strike your parents in a medical way to the extent that it's medically permitted, medically required. If you go beyond that, the consent of your parents is not relevant. And this is one of many proofs that Rabbi Zevin gives for his great principle, for his great law, that in Judaism we don't own our own bodies, that a parent does not have the privilege of waiving this commandment for their parents, and this further applies to any other situation, because we have a general commandment in the Torah not to strike and not to add to people's afflictions. The applications to this principle that we don't own our bodies is why this paper is cited again and again in modern halakhic literature in very modern context. I mean, this began as sort of an academic exercise to see how we evaluate something in Shakespeare, but it turned into something that everyone who writes about medical halakha and legal halakha has to deal with. The question of organ transplants, particularly organ transplants for money or voluntary transplants, it's a very difficult thing to permit under Jewish law, to have people sell their organs. And some people would like us to permit the selling of organs because there are so few, and that we would say that, well, there's all these kidneys out there that people could use. But if the kidneys don't really belong to the people, if the kidneys belong to God, I mean, we can't make it a monetary transaction for the organ. This comes into the principle of vaccinations. To not only do you have the idea that we have to be responsible for how our health affects other people, but we also have to recognize that we can't make the argument that it's our body, we'll do with it what we want. It's not our body, according to Rabbi Zevin. We have to try to figure out what God would want to do with this. It has ramifications in criminal justice, some of which have been recognized centuries before. But we have this principle in the Rambam that the relatives of a murder victim are not allowed to decline to prosecute the murderers, even though it was their relative who was killed. I mean, they killed a body that belonged to God. I mean, the offense was at God, and we have no right to waive that. And so this is something that I think of whenever you see you see it in the Boston thing. Some relatives of the people who died step forward and say, well, we don't want the death penalty, which they're allowed to do as citizens. I mean, anyone can be for or against the death penalty as a matter of fairness or whether it's a good idea. But to use your status as a relative, to think that your status as a relative of the victims gives you a particular weight in the debate is very problematic, because it's not just an offense against their relatives who were killed. It's an offense against society, and it's an offense against God. Of course, it has to do with the question of abortion. Many of the arguments on the pro-choice side of abortion come down to the question of self-ownership of the body. It comes into play in questions of cosmetic and sex change surgeries, which I was thinking of having a photograph of Caitlyn or Bruce Jenner to put up here. But the question is, to put it bluntly, do we have the right to alter what God has put into place? I see young people walking around with bodies that they've casually mutilated. I mean, they have big blocks in their ears that make their ears hang down, deformations that are very problematic to this principle. But all of them assume that it's my body, my choice. And even though Rebbe Zevin's principle is not unopposed in Judaism. There are people that oppose it. It's been very influential in halakhic thought, and if you want to enter into the debate on any of these issues, he's someone who has to be confronted. One final thing that I wanted to bring up, which is very interesting, to just show all of the different fields in which this article came to play a role. In 1953, there's what was called the Kibia incident. In Israel, it's called Operation Shoshana, or the Kibia operation. Outside Jewish circles, it's usually called the Kibia massacre. And what the Kibia incident was in 1953, that in retaliation for incursions that were made on the Israeli side of the border of Jordanian troops, the Israeli armed forces went into the village of Kibia and killed a large number of civilians. I think about 50 civilians were killed. This was a galvanizing moment in Israel and outside of Israel. Some of the reactions are very famous. We could do a whole class on responses to Kibia. Yeshayahu Leibowitz wrote one of the famous reactions, and it would anticipate his reactions to Jewish conduct in the territories after the 1967 war. And his essay after Kibia, he says, what has happened to our society? How is it possible that we've raised people, these were young men, how is it possible that people have been raised under the influence of Zionism to act the way that these soldiers acted? Another person who reacted to it was Rebbe Shaul Yisraeli, who was one of the giants of religious Zionism, the Orthodox Zionist movement. And he tried to address the question of civilian casualties through the lens of halakha. And one of the arguments that he formulated is that we have a principle in Judaism, dina malchuta dina, that the law of the kingdom is the law, and that he said what applies for a nation also applies to international agreements, and under a rule of international law, people consent to be killed in the enforcement of certain international norms. That's to say, because we all have a stake in a peaceful world and society, that we understand civilian casualties not as murder, because we all, by virtue of living in society and sort of consenting to an international social compact, we all consent that if the restoration of order requires our death, we're willing to lay down our lives for it. We've agreed in advance that we're going to do it. This argument is, of course, problematic on a lot of levels, but one of the levels that it's problematic is the thesis that Rebbe Zevin articulated, because Rebbe Yisraeli, in order to consent to lay down your body for the purposes of international law, you have to own your body. And that contradicts the klal that Rabbi Shlomo Zevin made, which is that we don't, in fact, own our bodies. And so they engaged in a great halachic debate on this question, and at the heart of it were the claims that Rabbi Zevin made in this, on the surface, very abstract essay, the Mishpat Shylock Lefi HaHalacha, that the law of Shylock according to Jewish principles, or the story of Shylock according to Jewish law. It shows, one, it shows a form of Judaism that's very engaged in what's going on in the world. It's a really remarkable exercise and a really great thing to see a play by Shakespeare, to appreciate it, and to say, well, let's try to evaluate it in terms of our tradition and our halacha. And by doing so, maybe we'll understand more about ourselves. It's not an argument in understanding the Merchant of Venice better. I don't think anyone who reads this essay says, well, now I get it. Now I understand what Shakespeare meant. But it is an exercise in understanding what Judaism is about. And sometimes in doing these exercises, we hit upon principles, we hit upon things which just echo throughout the other literature. And the fact that this essay about the play from Shakespeare is cited in so many halakhic papers, and that the argument developed and it has to be confronted in most issues of medical halakha, is something that just astounds me. People get tired of me saying that's the proof of God, but there it is. That's how I feel about it. And I've gone a little shorter than I usually do. It's been about 35 minutes since I've started, but that concludes the material that I have, and I'll just stay on for a few minutes to answer any questions that you might have. Ari asks, can a body part be sold by one spouse to allow the other spouse to travel to Israel to receive vital medical care? That sounds like a very practical halakha question. The way that you would have to, you'd have to. I don't know. You'd have to arrange it so that it was clear that all of these were for the purposes of medicine, and that's the sort of thing that I would kick up to a really good rabbi somewhere. I am not some guy in the sticks like me, but that's exactly the painful issues that you have to confront. And yeah, good question, Ari. Okay, I will. Then we will leave off here. I hope to see many of you in shul this Shabbat and to continue the class next week. I hope everyone has a good night.